Good morning. I'd like to welcome all of you to our public hearing into the inquiry into the accessibility and quality of legal representation provided by the state with specific focus on the Legal Aid and Advisory Authority and the Public Defender's Department. I'd like to welcome the viewing and listening audience to our 12th meeting of the Joint Select Committee on Finance and Legal Affairs. Today, the committee is convening the first public hearing pursuant, as I said before, to an inquiry into the accessibility and quality of legal representation provided by the state with specific focus on the Legal Aid and Advisory Authority and the Public Defender's Department. Members of the listening and viewing audience, you're asked to post or send your comments via the Parliament's various social media platforms, Facebook page, ParlView, Parliament's YouTube channel, and Twitter. We have our entities appearing before us this morning, the Legal Aid and Advisory Authority, and we have the Ministry of the Attorney General and Legal Affairs. So when we say Legal Aid and Advisory Authority, we also include the Public Defender's Department. I am Hazel Thompson-Ahi, and I'm the chair of this committee, and I invite members of the committee to introduce themselves.
Good morning, Chair. Good morning, everyone. This is Marvin Gonzalez, member.
Good morning, everyone. Terence Yal Singh, member.
Good morning, everyone. Jayanti Lachmigel, member.
Good morning, everyone. Lawrence Islop, member.
All members accounted for? Some members may be a little late in coming in. Now, I'd like the officials first of the Legal Aid and Advisory Authority to introduce themselves, please.
Good morning, Madam Chair and honorable members of the committee. Gilbert Peterson, Chairman, Director and Chairman of Legal Aid and Advisory Authority, and by extension, Public Defender's Department.
Good morning, Madam Chairman and other members of the JSC. I am Richard Raghubar Singh. I'm the Secretary of the Legal Aid and Advisory Authority.
Mendoza Mason.
She's having some technical difficulties, so she may join me while we resolve those issues.
All right. Proceed with the others, please.
Good morning to the chair and to the committee. I am Linda Green. I am the head legal of Civil Department at the Legal Aid and Advisory Authority.
Anybody else?
Good morning, Madam Chair and the other members of the committee. Stacey Wave. I am one of the established legal officers at Legal Aid and Advisory Authority.
Good morning, Madam Chair and other members of the committee. I am Leslie Pouchin-Turton, established legal officer at the Legal Aid and Advisory Authority.
Mr. Morgan.
Good morning, Madam Chair. Haseen Sheikh, Chief Public Defender, Head of the Public Defender's Department.
Good morning, Madam Chair and other members of the committee. I am Raphael Morgan, Deputy Public Defender of the Public Defender's Department.
Last but not least.
Indeed, so
welcome. Welcome, officials of the Legal Aid and Advisory Authority. And I must confess that this is an authority that I know very well. So let me put that on the table. I was on the board for 14 years. And I'm very happy to have you all this morning. Now we have officials of the Ministry of the Attorney General and Legal Affairs.
Good morning, Chair and members of the committee. My name is Natasha Barrow, and I'm the Permanent Secretary of Office of the Attorney General and Ministry of Legal Affairs.
Good morning, Madam Chair and members of the committee. I am Farzana Nazir Mohammed, Director Legal of the Criminal Justice Unit of the Office of the Attorney General and Ministry of Legal Affairs.
Good morning, Madam Chair, members of the committee. Pauline Guerra-Abraham, Senior Legal Counsel, Criminal Justice Unit, Office of the Attorney General and Ministry of Legal Affairs.
So welcome to all of you this morning to our inquiry, and let me remind you of the objectives: to evaluate the efficacy of the legal services provided by the Legal Aid and Advisory Authority and Public Defender's Department in relation to summary matters, civil actions, criminal procedures, and representation of minors in capital offenses via the Duty Council. And two, to assess the adequacy and effectiveness of the administrative systems and procedures of the Legal Aid and Advisory Authority and Public Defender's Department in the provision of legal representation. So you have a very, very important role to play in people getting their constitutional rights. And today we will embark on a discussion as to how well you are fulfilling that role. To begin, I will ask, speaking for just 2 minutes, that brief opening remarks be made by the head of your officials department. We'll take the lead.
Good morning again. As the chairman, I'm really here in support of my staff, if I may say so. I want to in fact, put what I will consider to be a comprehensive response to the invitation of this committee to attend and to assist in this topic. What I would say, Madam Chair, is that we at Legal Aid and Advisory Authority and now the Public Defender's Department, we commit ourselves to an adequate service from internal counsel, and where that is not appropriate or where it is proving to be impossible, we engage members of the private bar to assist us in discharging our statutory responsibility. I think we are to be judged by the public as to how well we do that, but speaking internally and a bit self-serving, I would confess that I think we have been doing a fantastic job with the resources that are available to us. And we can always do with more resources, but I think we have deployed the resources efficiently and effectively. And we have very hardworking and competent staff, and we continue to commit to the public that we will do our best to ensure that they get adequate and competent legal representation, which in my respectful view, it's a right that members of the public are entitled to, and it's a right to which we will seek to ensure that they receive. I thank you, Madam Chair, for those few moments.
Thank you very much, Mr. Peterson. I hope at the end of the day that we agree with you and your assessment of the wonderful work that you're doing, but that remains to be seen. But I see your defense of your department even before you are accused.
Thank you very much, Madam.
So I invite now officials of the Attorney General and Legal Affairs, Ministry of Attorney General and Legal Affairs, to make their opening statement.
Good morning again, Madam Chair and members of the committee. I thank you all for the opportunity to be here to discuss the efforts of the Office of the Attorney General and Ministry of Legal Affairs in supporting the Legal Aid and Advisory Authority and the Public Defender's Department. This legal aid was transferred to the ministry from the then Ministry of Justice since 2015. And since then, we have been making great strides in the efforts with regards to the Legal Aid and Advisory Authority. It should be noted, though, that the Legal Aid and Advisory Authority is an independent statutory body which consists of its own board and budget. And so its day-to-day operations are mainly managed at that level. The Office of the Attorney General and Ministry of Legal Affairs is the umbrella ministry responsible for the overarching operations of legal aid and by extension, the PDD. As the line ministry, it is our role to ensure that the Legal Aid and Advisory Authority and the Public Defender's Department are provided with the required support to ensure their smooth operations. And I do want to indicate that, we have been heavily involved in a lot of the issues that have been going on with the legal aid, and we have wholeheartedly supported their endeavors as we have moved forward, especially in the areas of digitization. And we will continue to support as we move forward, and they have been making great strides. I thank you.
Thank you very much, Ms. Barrow. You would have observed that in making his opening statement, the chairman director had a little rider there, He said, available resources, so that where they fall down, they say that you have not provided the resources. And you are, in fact, saying that, they're an independent body and so on, so that this is going to be quite an interesting discussion, I anticipate. So let me tell you how we're going to operate. We're going to start with the Legal Aid and Advisory Authority. And when I say Legal Aid and Advisory Authority, we're talking about the main department, and then we are going to go on to the Public Defender's Office. So even though it's part of it, of the Legal Aid Advisory Authority, the way it's constructed, and they have specific concerns, and then we will go to the Attorney General's Department. So we will begin our question interview, and I would like to start to say that I think that the Legal Aid and Advisory Authority has established a record for the entity that has submitted the most comprehensive response by way of a report. I don't know if they were planning to frighten us with your sheer volume, but we did go through the report, and very impressive statistics. So at least we know for one thing that you keep proper records. So, Mr. Raghubar Singh, thank you very much. And I am sure that Mr. Peterson would have advised you that, we have to dress to impress. So we have...
Well, just thinking, Madam Chairman. I mean,
it's just unfortunate that you have a chairman who knows legal aid. And I can tell you, you said that you used to be under the Ministry of Justice. You started off under the Ministry of Social Development.
Yeah, that's right.
I recall getting myself into a problem because when I decided to when I went to the Law Centers Federation in London, and they said, if you're doing legal aid, and I was director of the legal aid clinic, then you ought to have an information, out there. So if people don't know their rights, they can't come to legal aid to vindicate their rights. So I came back to Trinidad, because every time you go to somewhere, you must come back with something. And I said, I'm going to have a public education campaign over a period of 6 weeks. And I invited the Minister of Social Development, under whose ministry legal aid was. And we are Legal Aid Advisory Authority. And I can tell you, I understand sometime after that, the Attorney General and Minister of Legal Affairs was not at all happy because he said, well, I thought you would have invited me to open your training, your sessions, and you invited Minister Babulal. And I said, but I thought it was logical if that is the line minister, that I should have the line minister dealing with it, So now it would be the Attorney General and Minister of Legal Affairs. So that I think Mr. Sobian was a bit ahead of his time. Bless his soul. So today we commence with the Legal Aid and Advisory Authority in its original incarnation without the Public Defender's Department, which is the new baby on the block, the new kid on the block. And we're going to be hearing about how they're performing or not performing and how they remit. Because remember, we have a number of laws that impact on your department now. That wasn't there. We just had to deal with the Legal Aid and Advice Act. But now you have a number of other documents, and we would want to know what you're doing in terms of being sure that everybody is on board with all of the different laws that impact on the work that you do. So I just want to remind you to make your submissions to the chair, and any questioning will come to the chair, and so we wouldn't have all the crosstalk and so on. When you're not talking, you take your mic off, and it isn't always easy to remember, but somebody will gently remind you to take your mic off. They do that to me all the time. I cannot do without my procedural staff. They are, my left hand and my right hand. So we go to the Legal Aid and Advisory Authority, and they, as I said, have submitted quite a comprehensive report. I'm sorry that, maybe some other time we will give prizes for the best entity appearing before us, but not only in terms of the report, in terms of what comes out of our report in the end. So we begin. You are in the hot seat now.
Well, hopefully we can win that prize, Madam Chairman, in both regards.
Hope springs eternal in the human breast and in the Legal Aid and Advisory Authority. So we begin.
Madam Chair, do you propose to begin with Mr. Raghubar as the secretary, giving an overarching structure, then Ms. Mason, then we have the head of legal, and we have the public defender thereafter?
No, what happened, Mr. Peterson, is that this is no longer the submission stage. The submission stage is the paper, what you've sent to us. So this is the questioning stage. So that
I understand, Madam Chair, I understand.
Yes. All right.
Madam Chair, may I most respectfully ask to kick off the questioning, please?
But of course, Member
Thank you very much, Madam Chair. First of all, I would really like to congratulate Mr. Gilbert Peterson, SC, and the staff for undertaking the call to do public duty. As we know, it is not an easy job to be in the public eye and to do public duty. It doesn't pay much, and to have somebody of the caliber of Mr. Peterson, SC, is really testimony to his dedication to duty and all his staff. Madam Chair, the first question through you to Mr. Peterson. When we look at the raison d'etre of the LAAA, and if I may quote, to make legal aid and advice in Trinidad and Tobago readily available for persons of small or moderate means, and I'll stop there. My question is to inform members of the public, because I always say we are talking to the layman. And as Mr. Peterson will know, the man on the Clapham bus, or in Trinidad and Tobago, the man in the red band maxi taxi. What do you say to the population as to what is your understanding or definition of small to moderate means is?
But Senior, would you prefer Senior, would you want me to tackle that question?
Yes, sure.
Yeah, well, under the Act, Minister Dayal Singh and Madam Chair and Minister Dayal Singh, low to moderate means is defined under the Legal Aid and Advice Act, and so there are certain statutory limitations with regard to accessing legal aid, and I can briefly get into it. It would be maximum income of $36,000 per annum. Which roughly works out to $3,000 a month, capital, you can't have capital of more than $20,000 as a statutory limit in terms of people who are applying for legal aid in civil matters. But against all of that, you also have deductions that are allowed. So when somebody comes and says, well, okay, I'm earning $4,000 a month, and you work out the income, there are certain statutory deductions we can make in terms of the definition of low and moderate. And those statutory deductions are for personal expenses. We are allowed to deduct $4,300 per annum. For a child, it's $2,400 per annum to a maximum of 3 children per annum. So the maximum you can claim in terms of that deduction would be $7,200 per annum. And you also allowed rent if you are a tenant of $9,600 per annum, which can be set against whatever your total personal income would be for the year to get you to see if you qualify into our limit of $36,000 and less. So that generally is our definition of low to moderate within the statutory requirements of the Act for people to access legal aid. Now, that being said, I'd want to contextualize it that in terms of advisory services, people walking in or accessing our advisory services via our website, we don't we basically are non-discriminatory with regard to that. We would give people advice. Generally, people pay $50 to get advice, and they would get advice. We don't grill you on the statutory requirements then. Only if you're actually applying for legal aid and applying for legal representation, then we would have a means report done, which is done by one of our legal aid investigators, to see whether you qualify within this limit for accessing legal aid. Also, to further contextualize, the Director Chairman does have a discretion that he can exercise if somebody is over the limit, but due to extenuating circumstances, he believes that they should get it because of whatever circumstances. He can exercise that discretion, even though he doesn't exercise it individually. He usually brings it before the board, and the board will weigh whether it fits into the circumstance that an exception should be made. So that's how you access civil. Now, of course, Legal Aid and Advisory Authority has different components, and the Public Defender's Department is a component. And the access route for legal aid, if you have a criminal matter or a magisterial matter, is different. The statutory requirements that I just quoted here with regard to income does not apply. The magistrate or judicial officer, if whatever matters before the magistracy or whatever matters before the criminal court system, the judicial officer can decide whether you get legal aid or not in the interest of justice. And generally, once somebody has applied, generally judicial officers grant legal aid in the interest of justice. So the statutory requirement that I just quoted there will not kick in that circumstance. I hope that answers your question.
Madam Chair, through you, if I could just ask a series of short follow-up questions, because I have to leave at 11 and I would not trouble you after 11 o'clock. Thank you very much, Mr. Raghubar Singh, and you did segue into the Public Defender's Office. The Public Defender's Office, and I really want to congratulate former AG Faris Al-Rawi. This was his brainchild, starting with a cabinet note in 2018, and then operationalized in 2020. And we really want to thank Haseen Sheikh for taking up this challenge. I have a couple of questions. I'll ask all, and then we could go on. My big concern for the layman again, Section 5.2, Roman 2 of the Constitution, which speaks to someone choosing a defender of his choice. How does this legal aid, how does this Public Defender's Department which appoints a lawyer, dovetail or get around Section 5(2) Roman 2 of the Constitution? That's question one. Question two, how is the plea bargaining system working? And if Ms. Shea can give us some stats as to what the Public Defender's Office has been doing, because if I remember her quote when she was appointed, she did say one of the measures that will be used is easing the backlog of cases. So briefly, how is the plea bargaining system working? How is the judge-only trials working? If you could give us some stats there. And what systemic issues are you facing in sister agencies that you need them to assist you with to make the Public Defender's Department much more fit for purpose? Thank you, Madam Chair.
Madam Chair, are you permitted to answer these questions?
Yes, I just want to. We've indulged Member Dialsing because he's leaving early. So we'll allow you to take this question regarding public defenders, but then later on we will go back fully into public defenders. All right? So I'm spoiling Member Dialsing today. You know, he's a very, 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 very hardworking minister who's keeping us alive.
Thank you, Madam Chair. So if I can, I will address it in the order that it was posed. So, Madam Chair, through you, with respect to choosing the defender of his choice and with reference to the Constitution and the right to be able to choose an attorney of your choice, what we currently do in our system is that for every matter, and I should probably just put it in a little bit of context, at this point in time, the Public Defender's Department deals with High Court and Court of Appeal matters. The magisterial and criminal matters still lie with the Legal Aid and Advisory Authority on the civil side at this point in time. So for the High Court and Court of Appeal matters, for every matter that is requested for an attorney, what we do is we actually request the documents for that matter, meaning the High Court matter, the Court of Appeal matter, the notes that are relevant to the matter. We request it. We once received, we review that document in its entirety, meaning that we read it, all of it, and we determine the complexity of the matter. We determine the issues that have arisen in the matter, and based on that, we make a further determination as to whether it's something that could be kept internally. We have 26 attorneys, so we can't keep all. So we do make that assessment as to whether it can be kept internally. And if not, and it cannot be kept internally, we would then assess who is the best attorney in terms of seniority, complexity, and the issues arising on the matter to be able to properly assign. Now, of course, we always are mindful exactly of what Member Dialsing would have indicated in terms of choice. So if for any reason a person or a legally aided person requests a particular attorney, as much as possible, we do take that into consideration. We do try to facilitate it as best as we can, but it really is contingent on workload as well as the availability of that particular attorney and a number of other considerations. So that would be the first question. I don't know if Madam Chair, if Member Dialsing has any further follow-up before I move on to the other.
That's fine, Ms. Shea. Thank you very much.
Grateful. So with respect to the second question, Madam Chair, which is the plea bargaining system and how that has been working for us, at the back of that very lengthy submission that we have put forward to the committee, there is, I could actually direct you to the page, I think it would be page 42 in the appendix 1 of the public defender's submissions. We do go through how the matters have been disposed of and how it has been working. So right now we have disposed 23 matters via guilty plea, which was done pursuant to the plea agreement. And of the 23 matters, 4 of them had started prior to us. So it would actually be 19 matters that would have completely originated in the Public Defender's Department. So that is disposition to date for plea bargaining. What just to also put this in context, we have a number of matters at any given time that that are basically going through the plea bargaining process. In terms of the fact that we do have to liaise with the DPP's office, we have to provide the submissions, they have to respond to us, we have to engage in discussions. So it is not as cut and dry as you send a request and you get an immediate response. Sometimes it takes 6 months, sometimes it takes a bit longer. And I think that might actually tie into one of the other questions that Member Dialsing would have asked. So, but at this stage, we have 19 matters that have been completed via plea bargaining. With relation to judge-only trials,
Ms. Sheikh, just before you go, just for the public to know again, as I said, the man in the red band max taxi, how long does the plea bargain case take as opposed to going to judge and jury on trial, so they can know how well this is working?
Well, if I'm going to put the 19 matters in context of how many have been dealt with in the past 2 years, so we've only been established in March of 2020, I would have actively received the vast majority of detainees by July of 2020. So between July and now, which brings us to about the 2-year mark, we have actively completed 19 matters. So, and to put that in context, when you think that the average matter takes anywhere in excess of, from start to finish, 10 to 15 years, looking at 2 years to go through the process of plea bargaining, you're actively finishing a matter in a much quicker time frame. And it's not just that you are dealing with the matter and having to go to the court and go through that whole process. You're dealing with it outside and then you're going to the court when you have completed. So it is actively faster in terms of it. But ultimately, the plea bargaining matters we have dealt with are only at the High Court stage. This is not to say, of course, that it cannot be done at the magisterial stage. The Plea Bargaining Act does allow for that to be done as well. So there is a great ability for plea bargaining to be used across the board. So it is not just at the High Court stage. It can be used, but that is how we have been using it thus far. If that gives the clarification, please, Member Dialsing.
Yes, thanks.
Thank you. To move on to the third question, Madam Chair, with respect to judge-only trials working. Again, I'm going to see if I could point to where we have been doing trials. So that would be on page 41 of our appendix, which speaks to how many trials we have done. At this point in time, we have conducted 9 judge-alone trials. And at the time we submitted this report, since then, we have had 2 more that are in progress and that have not been completed as yet. We've had, basically almost down the middle. We've had 4 guilty, 5 not guilty. So it could go either way, really and truly, of the 9 trials that we've had. We have taken the approach in terms of trying to go to trial for matters that need to go to trial. So not every matter that comes to us is a matter that we think that actively has to go to trial. So once we speak with our clients and we're able to deal with it via the plea bargaining route, we do that. If there is an MSI option, maximum sentence indication, and they're able to choose that option, that is also something that we have actively been pursuing. So that is also a reflection of why we would have 9 judge-alone trials and a number of other matters being disposed of in other forums rather than trials. Of course, we can only speak about judge-alone trials for the duration of our time frame, because since we've started, COVID started, and we didn't have any jury trials since then, and we have not, despite jury trials being started again, we have not engaged in any to date. So we have had only judge-alone, and thus far we cannot so we can't speak to the jury, but we can speak to the effectiveness of the judge alone. They have been primarily virtual. And as a result of that, I think we've actively been able to accomplish it. We have had the benefit of assistance in terms of getting our virtual setup. We have a room that is set up for judge alone, where we're able to conduct the judge alone trials. We have the internet providers. We have multiple internet providers actually to ensure that we're always able to conduct the trial. So we have put the necessary technology in place. So we have not had any problems on the judge alone front and being able to actively participate in it.
Just to clarify on judge alone trials, I remember when former AG Al-Rawi was doing this. Of course, we're plunging into the unknown, and change is something that is not normally readily accepted. Now that you've had the experience, do you think that the average person appreciates a judge alone trial as opposed to judge and jury?
The average person?
Yeah, who you represent, who goes before a judge alone? Do you think there's public buy-in? The man in the red band maxi taxi, are they buying in to judge alone trials? Because there was a lot of talk at that time, if I remember, that this would not work.
I apologize. I believe I missed a moment of what you were saying, Member Dial saying, because I was reconnecting for some reason.
As I said, when former AG Al-Rawi was piloting this, plunging us into the unknown, into something new and novel, there was a lot of talk that this system will not work. With your experience now, with 2 years experience, do you think the judge alone trials has caught the imagination of those who are benefiting from it? The man in the red band max taxi, the man in the Clapham bus.
Well, I think that I apologize. Are you hearing me, please?
Yes, we are.
Great. So in terms of the capturing of the man in the red band bus, I think it's twofold. I think the lack of ability to have a jury trial meant that it allowed for more persons to actually consider judge alone trial, because they did not actively have that consideration before, because they had another alternative. So once they had that other alternative, it was something that they considered first. So with the removal of the jury trials due to COVID, it meant that this is the option that was available to them. I think what it allowed for is for robust consideration of the issues so for each accused person, there was robust consideration of the issues between the client and counsel and determination of whether this matter was a good fit for judge alone trial based on the issues arising. And I think based on that, there was actually a move towards judge alone for a lot of persons who did not prior consider it to be an option.
Thank you.
And if I might be permitted to answer the last question, Madam Chair, with respect to systemic issues and other agencies, I think as a department, the Public Defender's Department, as a stakeholder in the criminal justice system, we can be only as effective as our counterparts. And I think one of the issues has been and continues to be some of the issues that happens at the Director of the Office of Public Prosecutions in terms of staffing, their workload, their ability to be able to actively move matters along. I think that has definitely been a problem, but I do know that there's been a lot of active movement in terms of filling the staff shortages. So we are hopeful that that particular issue should be resolved. So I think that would be one of the systemic issues that we would have addressed, or at least identified, and hope that it is being addressed in such a way that we'll be able to actively move forward.
Okay, thank you, Madam Chair, for allowing me and spoiling me this morning. But as I indicated earlier, I do have to leave, but thank you very much for accommodating me this morning. Cheers.
And since we started off with Public Defender's Department, I think it might be logical to stay with her and then go on to the General Legal Aid and Advisory Authority. So instead of going back and forth, we have her in the hot seat. So let's take it from there. When this department was conceived, the objective was in assisting with the chronic delays and backlog in the criminal justice system. That was the laudatory objective. Do you think you've achieved that objective somewhat? Have you really contributed to the chronic delays? And if not, what has hindered you from making a more significant impact on the criminal justice system?
Thank you for the question, Madam Chair. In terms of our impact, I do think that we have been able to actively assist. One of the considerations for the establishment of the Public Defender's Department was there being a shortage of criminal attorneys at the private bar who were able to actively do matters. The criminal bar is notoriously small for a number of reasons. I think criminal law, for some reason, is not as attractive as it should be. And so there are not that many practitioners who actively choose to do criminal matters. So that was the first reason. So being a small pool of attorneys, it meant that there could only be so many matters done at a particular time. I'm sure Senior might be able to give numbers better than I can, but I average that there are no more than about 20 odd persons who practice fully at the criminal bar. So when you factor that type of number and you consider the department where we're at right now, and we're at 26 attorneys, and we have a maximum capacity of 38, that in itself allows us to actively treat with that major problem, which is capacity, the number of attorneys that are available to deal with criminal matters. So that's the first way that I think we've actively contributed. In terms of looking at how many matters that we currently have, and I'm just trying to get the numbers that we currently have. I'll perhaps come back to that. I'll just ask Mr. Morgan to just see if he can help us with that number. In terms of the numbers that we currently have, we try to keep as many matters internally as we physically can for the numbers that we have. So it means at this point in time, I think our average caseload per attorney is 15. So each attorney at the minimum have 15 matters that are assigned to them. Now, this helps in two ways. One, that this attorney is assigned to this particular matter from start to finish. It's not a rotating docket. It's not a situation where it keeps moving from this person to the other. They are assigned this matter. They see that matter from start to finish. We think that that's a very effective way in treating with the matters and allowing for continuity and allowing for good representation. So that is another way. Thank you very much, Mr. Morgan. We have 336 matters that are assigned internally to the Public Defender's Department. So at that time, so that's another mechanism that we have put in place. Now, why I say that is important is because previously, with no Public Defender's Department and having only the legal aid panel, what it meant is that you were assigning matters out to the external bar, but we had a continuous merry-go-round of reassignments. Matters kept coming back in, and we had to continuously reassign. So it meant every time that matter was reassigned, then it would lead to essentially starting over in the queue, because that new attorney has to start from scratch, start over, and so forth. So that's one other way I think we have actively treated with some of the systemic problems that existed as to why our department was created. So those are two areas. Another area that I can point to, which I think has effectively assisted, and I think Member Dialsing touched upon it, is our active approach of seeking to treat with matters at the earliest available opportunity. We are not necessarily waiting for the trial date. We are actively evaluating the matters internally. We are deciding if these matters are able to be pleaded. So if there is an available maximum sentence indication option, if it's a matter that can be beneficial of a guilty plea, if we need to write the DPP's office under the Plea Bargaining Act, that is something that we are doing and have been treating with. Now, if I can just point to one statistic that I think is pretty important. The external bar currently consists about a little over 200 attorneys compared to the 26 attorneys that we have internally. The external bar over the period 2020 to 2022 completed 50 matters. That's the current matters that happened by the external. We have completed a total of 49 matters in the 2 years over our 26 attorneys. So when you make a comparison there in that and of itself, where you have 200 attorneys, give or take, who have matters, who have completed 50 matters, and we have completed 49 for 26 attorneys, that's something I think that should be taken into account in terms of us trying to move matters. So that is another area, I think, in terms of how we have treated with dealing with the backlog. The final area, because I feel like I'm answering for a very long time, Madam Chair, I apologize, that I want to go to, and I'm happy to clarify later on with any further questions, is that part of dealing with the backlog is not only actively moving matters, it is being able to build our capacity to move matters. We have been due to COVID, we have been hamstrung to an effect because there weren't as many matters being done. We didn't have the ability to do jury trials. Some of our clients want jury trials, so there's very little that we can do to change that. But what the department actively did in the past 2 years was engage in a number of things. We are fully electronic. We have engaged in training upon training to ensure that we are not just providing a service, but we're providing a quality service, so that once the courts are up and running and moving and giving us that opportunity to move matters, we are ready and we are at the capacity level to do it and to do it well. And I think that's also a very important consideration in terms of what we have done to be able to get towards that backlog. We may not be able to show it all in numbers, but we have put in the work. So that is what I think I can point to at this stage. I'm happy to answer any further questions.
Madam Chair, if I may, I have a question for the Public Defender's Department through you.
Please proceed.
Yes, thank you, Chair. Through you, Madam Chair, I just wanted to find out all of the explanations given by Ms. Sheikh, which I appreciate and I understand what is being done. But was there any specific reason, legal, legislative, or policy reason why everything that has been described as being done through the Public Defender's Department could not have been done through the Legal Aid and Advisory Authority in terms of recruiting full-time attorneys to be assigned to criminal law matters? Because I know the challenges with having external counsel come on. Building the capacity in-house. Was there really a need for a separate department? What was the challenge and what was the driving factor behind having a separate authority called the Public Defender's Department, as opposed to strengthening the capabilities and the resource allocation to the Legal Aid and Advisory Authority?
If I may take that, Haseen, Member Lakshmi Dial, what would have happened is that in the there is a conception, I suppose, that the Public Defender's Department is a separate entity to the Legal Aid and Advisory Authority, and it is not. It is a component of. Prior to it being established, we had, in terms of our cadre of in-house attorneys, we would have had attorneys who did criminal matters, but it was a small criminal core in terms of dealing with those matters exclusively. And what you would have also had would be attorneys doing civil matters. They may be doing a divorce, and they also have a criminal matter. So in looking at the strategic development of the legal team, we felt the time time had come to separate them clearly in two parallel tracks. So you'd have civil and advisory, and you'd have those that were doing criminal who, if they wish to continue doing criminal only, could move across to the public defender's department. And so that's why the public defender's department was established. So it's still under the rubric of legal aid and advisory authority. People may think it's separate, but it's not really. It's internally, it's a department. And so its allocation is the allocation of the LAA, the LAAA.
Right. So I think that's, as you said, a public misconception, and we want to be corrected, because a lot of people feel that different departments are being created. So that's one thing. Another question, well, as I have you, I don't know if you or Ms. Sheikh would want to take this question, but through you, Madam Chair, you mentioned about when we started, the criteria that someone has to meet if they want to have legal aid. And I know from experience that means assessment is sort of done with divorces and all of that. But on the criminal track now, the magistrate or the judge can approve the person. Do you feel that this is the most efficient use of your resources when anyone who applies without a means test being done? Because I don't believe any sort of means test is done when the judicial gets involved. They simply can make the recommendation or approve the person for legal aid. Do you feel that it would be a better use of your resources if persons who before the criminal courts, the High Court or Magistrates Court, would go through that means assessment test as well? Because in my experience, let me be clear that I've actually been doing I've done duty counsel, I've done magistrate court assignments from legal aid, as well as high courts on the civil side. And sometimes I meet persons who are assigned legal aid, and I'm thinking to myself, well, that handbag looks really expensive that you came to see me with here today. And I'm wondering if these people ought to really be afforded legal aid, because there's no means test done at the judicial level. So what's your thoughts on that, and given your resource constraints?
Well, I suppose Hassan can weigh in. I mean, I could just give my thinking. I don't know if Senior would want to comment here too. But the issue of the judicial officers being able to grant without a means test is really codified in the Act. The Act allows that in the interest of justice. And I think because the criminal system is so backlogged, and adding another bureaucratic step for a matter beginning, which would also require resources, because the judiciary is not going to do the means test. They're going to say, you do the means test. So it means it's going to actually require further resources from us to deal with the huge amount of clientele that we have in the criminal system that's divided between the magisterial and the High Court and the Court of Appeal. So the interest in I think the framers of that act, when they framed it, they understood that in the interest of justice, even though somebody may, if you were strictly looking at the means test, may not qualify, in the interest of justice, because sometimes somebody may be charged, they may have assets, but they can't access it. Yeah, sure. So in the interest of justice, that's why that was stated there as an access point into the system. I don't know if Ms. Sheikh or Senior would want to weigh in on it, but I think that's the qualifying issue. It's going to add another bureaucratic step. There's already a backlog, which we know, and so judges and magistrates use that to try and speed up the process of making sure that an attorney is assigned to the client before the court.
Understood. However, through you, Chair, do you feel that it puts it really puts too much of a heavy burden on legal aid, because we have about 14 magistrates courts, all the different high courts sitting and so on, when they can simply approve someone, and then it's the ball is thrown into your court to find someone to then step up and take this on in the interest of justice. I understand the reasoning and the logic behind it, and I understand the extra step, because then if the person goes through a means test on your end, when they are referred to you and they don't meet the criteria, you have to send it back, and then it can cause a delay in the trial starting. But at the same time, we have to balance, I think, the use of resources. If persons, legal aid from the point of conceptualization was really meant for those who cannot afford legal representation, and of course people not being able to access their assets and so on is a factor, but shouldn't there be some greater assessment of those factors before we devote the resources of legal aid to a person? So that's one question. The second question is, as you spoke about the strengthening of the track of criminal matters, by hiring persons who want to become, and hiring more persons in-house on the public defender's department side, is there a corresponding attempt or any plans to do the same thing on the civil side? Because civil trials are also becoming a bit, which are a lot more intensive in terms of timelines and meeting very strict under the CPR deadlines and so on. And when you are briefing matters out to external counsel and it's being returned and you have all of these things happening, it causes delays, do you see yourself as also moving in the direction of having more permanent in-house attorneys to handle matters on the civil side as well?
Well, if I may answer the second question first, and the first question maybe could be Asset Hassin or Senior could weigh in on it. But the second question with regard to the civil side, we do have a civil side. There is a mirror, if you want to look at it that way, of civil and advisory, because it's civil and advisory. These are the attorneys who will actually advise walk-in clients or clients via the website, etc. And of course, we are moving more and more into the digital realm, and we are going to eventually be doing virtual advice for people who can't come into the brick and mortar offices that we do have. So we do have that civil side. That civil side under our relatively new head legal is now being retooled to do exactly what you're suggesting, Member Lakshmi Dayal. So it is in train, and we are now building up that kind of capacity for a lot more internal civil matters to be done. With regard to the civil bar, the civil private external bar, you do have much less exchange of briefs that would have occurred in the criminal bar. So generally, when matters are assigned for civil matters, and depending on the complexity, that will also be, evaluated before we send it to whichever civil lawyer from the external bar. Those matters from the civil bar experience, there are less returns than would have occurred in the criminal external bar, which Hassin would have touched on. But yes, to simply answer your question, yes, we are building capacity. They are going to start going into more and more training in terms of us dealing with much more. We do deal with civil and estate matters now. So, but a lot of our civil workload is family oriented in terms of divorces and other family-like matters. We do a lot of those in-house. But we are expanding into more and more complex civil matters. With regard to the first question, I don't know if Hassin wants to take that one.
Madam Chair, if I could also begin on that first question through you, Madam Chair. Member Lakshmi Dayal, that is, you raise a very, very pointed question. It's a question that, as Director Chairman, I've been weighing in my mind, and the problem, I suspect that the thinking behind the legislation had to do with the fact that if you are charged with a criminal matter, then you should have access to legal representation, and that is what also informed us establishing the duty counsel scheme, where persons could have access to legal advice very early in the process. There will be, to answer your question squarely, there will be persons who will slip through the system, who will have the resources and will also benefit from legal aid assignment. But from my experience, I think it balances off in the sense that persons with the resources will tend to seek counsel from the private bar. There will be one or two who will try to benefit from the system and say, I could get an experienced counsel from legal aid. I could get a senior counsel sometimes from legal aid, and that happens. But most times, I think it balances back, and I think the thinking behind not requiring the means test is to ensure that persons' rights are protected and they don't incriminate themselves and expose themselves to criminal sanction as opposed to civil proceedings. But it is a valid point, if I could respectfully say so. It's a point that has occupied our mind for a while, but as Mr. Raghubar Singh said, the statute allows it, but it's something that we have always been keeping an eye on.
Thank you, Senior.
If I may, days when I sit regularly in court, I would hear the magistrate make inquiries of people coming before them to try to ascertain their means. So, to be fair to the magistrates and so on, they do, and the judges, they sometimes make, maybe cursory, not in depth, but they do try to find out the means of the person before referring them to legal aid. I don't know if things have changed, but I remember that used to be the practice. I want to find out if you, in terms of the defender's office, the people who are employed there are salaried people. And because they're salaried, it doesn't matter how many matters they attend to, but each one you'll be saving the state money that you'll be paying to private attorneys. So having regard to the amount of money that you've been putting out there in the past, do you see that establishment of that public defender's office has actually saved the state some money that they would have been paying to lawyers, for in private practice? And I also wanted to find out is if there is any investigation or double checking of investigators, because that is also an area where you can have fraud, where people would go out, as investigators, and in the past it has happened, and given somebody aid, you recommended, but there's no check and balance to see if that person really qualified, but there is some collusion between the staff member who's employed as an investigator and the person requiring aid, that I'm going to recommend you for aid, when in fact that person doesn't really qualify. Because if it's a salaried worker, it's easy to check, bring in your pay slip and all of that. But someone who is, eking out an existence, purportedly eking out an existence and saying, well, I just, have a little store, or I just manage a little business, and there is not paperwork to actually substantiate that, So I'm just wondering, in terms of your investigations, if there is any way of validating the information that comes to you. And I just want to tell you a little bit of history. Unfortunately, in the past, there was a case that before your time, when there was an investigator with very detailed reports, extensive reports. And one day somebody walked into legal aid and said, but nobody has been to see me. And that's when we caught what was going on. He or she should have been in fiction writing, because those reports were so detailed that we could not believe it. So we had to go back and all of that. Well, the person was fired, of course, but it's always bothered me as to whether, in fact, there is any check on the investigators, because, we are in the smart man country. Yes, it's no longer, we used to think growing up it was the Bajan is the smart man and the Guyanese, but now we have a lot of them in Trinidad. So that's, a way where the state can lose money because of collusion. And, is there anything, Mr. Raghubar Singh or Mr. Peterson, where you can actually double check that the people who supposedly qualify for legal aid are, in fact, first of all, are they investigated at all? Or if they investigated, that's the truth that is coming to you, to the board meeting.
Yeah, but Madam Chairman, I could come into defense, I guess, of our legal investigators department. There have been training sessions that have gone on with the legal investigators department, including from members of our board who would have done some of the training with them. And with regard to writing means report and the kind of verification processes that they would have need to present. So they do have to go through bank statements. They do have to go through verification, not only from the client themselves, the prospective client, but also from neighbors and people adjacent in the neighborhood. They do that kind of reporting. They are required to visit the person's house, do different verification checks. And when those reports, because I know you're going to the integrity of the legal investigator, those reports are vetted by one of our senior legal officers who is present in the meeting here. And that vetting takes place, and anything that looks suspect, that doesn't seem to fit in with the modality of what that means report is supposed to say, is double-checked or referred for further verification. Now, can somebody get through the system? Can there be a possible gap in the system? Yes, you can't, no system is 100% foolproof, but I think our system is pretty robust in terms of preventing that kind of fraudulent behavior in terms of our legal aid investigators and our legal aid assistants.
Yes, but as I said, in that case, even neighbors had been investigated. Neighbors had put in papers. Of course, none of them existed. It was a pure fiction. I think it was an amazing person, but these things happen. So I'm hopeful, and I'm glad that, your system is robust. We thought the system was robust too back in the day, but that one slipped through. It was an amazing, I don't know, she could have been given a prize. It was excellent report, excellent. Everything was there.
Okay, I mean, that's before my time, I think. But
of course, it was. It was before your time. Definitely before your time. I was there from 1987 to 2001, long before your time. Mr. Scotland, who joined us late, he had his hand up. Mr. Scotland, have you disappeared? Well, maybe he disappeared for a while, but I must apologize, but I was allowing Ms. Lush Media to ask a series of questions. Yes, and Mr. Hislop.
Thank you, Madam Chair. You all hear me fine? Right. I want to first congratulate the Legal Aid Authority on the work they've been doing over the years. But I just want two simple questions. One is for my knowledge, because I'm new to the committee and new to maybe a lot of the integral work that you're doing. So the first question is, what prevents the plea bargaining from being done at the magistracy court level, as well as what is for both the legal aid and public defenders, what is your establishment like in Tobago in terms of what is the work that you have been doing in Tobago over the years, especially the public defenders department, as it is a more recent entity or a recent addition? So those are my two questions for now. So to anyone of the team who's here this morning could answer.
Sure. Madam Chair, through you. With respect to the first question in terms of what prevents the plea bargaining at the magistracy level, nothing, absolutely nothing prevents it. The Plea Bargaining Act allows for plea bargaining to happen basically at any given point in time. It actually allows even prior to charge. So it's not, at any given time you can engage in plea bargaining. Why the Public Defenders Department specifically engage at the High Court is because we are not actively in the Magistrates Court at this point in time. And with respect to the magistracy matters, they are primarily given to the external bar. So that becomes a conversation between those external attorneys and the clients as to whether they wish to engage in plea bargaining. So it is not that it's not something that could be pursued. It absolutely can be. It's just a question of, strategy and tactics and instructions at that stage from the relevant clients and how they choose to pursue it. So that's with respect to the first question. And with respect to what the Public Defenders Department is doing in relation to Tobago. So the Public Defenders Department, we are based at the head office of the Legal Aid and Advisory Authority in Port of Spain. All of our officers, all of our attorneys are here. But because, especially through COVID, I would say we've been, lucky enough to be able to do virtual everything. So we have been actively able to be in all whether it be Port of Spain, San Fernando, and Tobago, we've been able to conduct all of the different matters. We have had at least 2 Tobago trials out of the 9 trials that I would have indicated that we completed. 2 of them were Tobago matters, one of which we actually conducted from the Legal Aid and Advisory Authority's office in Tobago. And so we are actively treating with Tobago matters that are of the High Court and Court of Appeal level. So yes, and Mr. Morgan is currently pointing out that we're currently concluding a 3rd. So we are active across the jurisdictions. We are not limited to any one area. We do all of the matters. Our attorneys are operating across the board. The court system has been, it's been streamlined. So we're doing Port of Spain, San Fernando, Tobago, and we are actively, our attorneys, prior to the shutdown of the Tobago Air Bridge, Sea Bridge situation in COVID, we were actively going at least once a month. One of our attorneys would go and meet with clients and so forth. And we have started back that process to some extent, where we go to Tobago when necessary to treat with clients, to take instructions, to interact with them and so forth. So we have an active presence with respect to Tobago, even though we're not based there and we don't have any attorneys stationed there, but we are doing what needs to be done.
Thank you. Just a follow-up. Are you looking forward, or are you actively pursuing having attorneys based in Tobago? I know the technology has helped. I know the technology has really helped. But are you actively pursuing that?
I'm going to leave that question to Mr. Raghubar Singh and Senior, and perhaps one of them maybe.
We do have attorney. We have a full-fledged LAAA office in Tobago that is manned by an attorney presence there, so people can come into the Tobago office. But if you're talking about public defenders being actually based at the office, that's as Haseen would have indicated, that has been an as needs basis in terms of public defenders going up when required. Exploring the possibility of having public defenders based in Tobago will always be part of our long-term planning, because the Public Defenders Department is still relatively new after 2 years. And certainly we have a Tobago member of the board is from Tobago and certainly advocates very robustly for things Tobago. So it will be part of our future planning out.
Thank you. Now I must have Mr. Scotland. His electronic hand has disappeared. I don't think it got cramped. So Mr. Scotland, and then I will have Member Hussain. Yes?
Yes. Madam Chair, I want to direct this maybe to learned senior counsel. The history of legal aid and the criminal bar, Madam Chair, has always been that the legal aid has afforded persons in need very experienced counsel, sometimes even senior counsel, going as far back as the State and Chuck Atten, at a very reasonable and underpriced. Would the coming of the Public Defender's Department affect that stream, that genre, where very qualified attorneys would be able to represent needy clients at a whooping reduced cost, but with representation that is stellar?
Madam Chair, if I could take a shot at that. That feeds from the question from Member Lakshmi Dayal and part of a question from Member Dayal Singh. The point is that, first of all, there are very experienced lawyers on the external panel. And sometimes we attempt to give persons the lawyer of the choice, which is one of the questions Member Dayal Singh had raised. How we approach that is that you consult, since the lawyer is a very senior lawyer and may be busy, we consult that lawyer and find out if the lawyer is, first of all, available and, first of all, interested in accepting that brief. If the lawyer says yes, then the person who is requesting that lawyer will get that assignment. Now, we have public defenders, yes, but if the person doesn't request a particular lawyer and we can accommodate it within the department, then a public defender will be assigned. If the person requests a lawyer who's on the panel outside and the lawyer has agreed to accept it, then that matter is assigned to the external lawyer. And we sometimes also appoint someone to appear with the senior lawyer, someone from inside, from in-house, as the instructing attorney. But I also wish to say, and this will cover some of the questions raised with respect to the public defender and the question raised by Member Hislop with respect to establishing permanence in Tobago with respect to public defender. The public defender department at this stage is a pilot project within the Legal Aid and Advisory Authority. Based on the statistics, and this may be self-serving if I say this, based on the statistics, I think this pilot project is commending itself to becoming something permanent and no longer a pilot project. And we have a vision of expanding that into a public defender for children and subsets of the greater public defenders department. So I just want to put that in context, that the PDD is really a pilot project, which I think has earned its keep and is likely on any assessment to be a department that should be kept and expanded.
Earned its keep financially?
In delivery of service, ma'am. But, Madam Chair, but that point you made is something that we have been considering, but not in detail, with respect to the cost of the department and the money we save. I think when one do the assessment, I think notwithstanding, if even we are off on course, which I don't think we are, I think the benefit of the department will justify its keeping. For example, the point Ms. Sheik made about when you assign matters to the private bar, there are a lot of matters that is a revolving door. You send it to one lawyer, after 2 or 3 months, they run into difficulty with their diary and they send it back. Then they assign it again, and 2 or 3 months, the same thing happens. So sometimes you could find a matter being reassigned 3 or 4 times within 18 months or 2 years and nothing been done on it. Whereas in public defenders department, it's likely to have been completed within a year. So even on that benefit alone, apart from the dollars and cents, it did justify its existence.
No doubt, no doubt. Let me have Mr. Member Hussain, please.
Thank you very much, Madam Chair. Can you hear me clearly? I know I had problems with my microphone earlier.
Loud and clear, we're hearing you.
Perfect. So I just want to ask Ms. Sheik one of the questions based on a comment that she made, in that she attributed one of the lags in the criminal justice system and one of the impediments to their work on the systematic issues within the criminal justice system, and she pointed out that of the Office of the Director of Public Prosecutions. Now, I'm going on my memory here, and to the best of my recollection, Madam Chair, so please excuse me. I remember that there was a symposium at one point in time where the Director of Public Prosecutions commented on a plea bargaining symposium under the memory of late Senior Counsel Dana Sitahal, where he would have said that the time has come where we use the legislation, but the enforcement arm of the state, the police, needs to front load the matters, meaning that if an accused person is faced with a front-loaded case in terms of forensic evidence, proper investigation done, witnesses available, it is more likely that person will enter into some plea arrangement instead of going to a full-blown trial, because you will have the discounts when it comes to sentencing in terms of a guilty plea, first opportunity, not wasting the state's resources. So can Ms. Sheik indicate whether or not that has been an issue with respect to how cases move within the public defender's department in terms of how the length of time or the delay that forensic evidence takes to be disclosed to them by the prosecution arm of the state?
Okay, Madam Chair, through you. Thank you for your question, Member Hussain. In terms of the disclosure specifically of forensic evidence. I mean, we've had some challenges, which I think, luckily we have representatives from the Office of the Attorney General and Ministry of Legal Affairs here who have actively tried to assist in that regard. And we have had a committee that has been established to deal with the backlog of forensic evidence and DNA evidence and so forth, and treating with that. So I think we have actively put some degree of plan in place with respect to that part of it too. I mean, ultimately, the DPP's office cannot disclose what they do not have. So that's the first thing. So in order to get those reports and so forth, other agencies needed to be brought up to speed, and whatever necessary improvements needed to be effected, needed to be done. So I think we have treated with that to an extent, and I'm sure they can give you more information with respect to that aspect of it. In terms of the front-loading issue that it would allow for pleas, I think it's not so much, I mean, the police investigation, I think, there's always room for improvement there. Let me put it to you that way, right? There's always room for improvement there, but I don't necessarily think that my clients will complain about that. But, ultimately, if they were to do their job effectively, obviously it would mean that the information is available at an earlier stage. We would be able to move faster. We would be able to do all of those things. But I think in the context of what is being asked, I think the DPP's office rely on the police complainants to provide the information. Ultimately, they do not necessarily have a full docket. Sometimes they don't even have all of the statements. I mean, I am mindful that sometimes the blame falls on the DPP's office, but it may not necessarily always be them. And I think we have to be careful about how we section blame. And I think that in light of them, the DPP's office having to work with the other agencies to get the information, yes, if everybody were to play their part, then we would get disclosure at an earlier stage, and we would be able to plea bargain at an earlier stage, and we may be able to dispose of a matter at an earlier stage. But again, it really is a lot of moving parts, and I agree with you. The more that we get up front, the better able all parties would be to actually determine what is the best way to move forward and whether a trial is necessary. Because ultimately, we cannot try all of the matters. So if we were able to get to that stage, I do think it would be helpful in terms of, achieving that end goal. I'm not sure if I answered your question, Member Hussein, but I hope that I touched on it at the very least.
No, you did. And I want to agree with you from experience in the DPP's office that it's difficult for most of the time for the prosecutors to actually get the information, the evidence that is close to the defense. Madam Chair, if you would permit me one more question, and I think I'm going to touch on a very controversial part of the proceedings today in terms of the work that the public defendants do. Recently, everyone knows that there has been a groundbreaking judgment in terms of persons who are accused of murder can in fact make an application for bail. Can you indicate whether or not your office have been met with any of these applications, and if so, how many?
Madam Chair, through you, most of our murder accused would love to have bail. I think that's across the board. Anybody who wants to go home with their family, I think across the board, we have had quite a number of persons express an interest for bail. We do not currently have any active bail applications before the court, and the reason for that is simple. We are an interested party in the Joel King appeal that has been before the Court of Appeal that was argued at the end of May. We did participate in that appeal. We are waiting some level of decision with respect to that to get some further direction as to how to treat with particular matters. A lot of the accused, they do know that they can go before a judge as well, but because of the particulars of bail for murder and it's a little more detailed and a little more rigorous than the average bail, we have taken the approach of being very careful about how we are doing it and the information that we put forward. So it is something that we have been actively doing for our clients, but we're doing it in a very systematic way.
Can I have Member Lakshmi Dale and then Member Scotland, please?
Thank you, Chair. So I just want to be clear. I had some other questions about the duty council scheme, but based on that last answer from Ms. Sheikh, I just want to be clear. You said that you all were an interested party, which I am also an interested party, by the way, in that bail for murder matter, which has gone to London. But, you know, as an interested party and as a department that falls within the, at least financially and administratively, within the structure of the Ministry of the Attorney General, do you feel conflicted in any way in terms of your ability to represent murder accused who you are supposed to be providing a service for? Because persons who are privately represented have made and have successfully made applications for bail, seeing that the Court of Appeal refused a stay by the state in order to, to prevent the ability of persons to apply for bail. So, I just wanted to comment on that. I mean, don't you feel that persons represented by the Public Defender's Department should have the same sort of active and enthusiastic representation as persons who are represented by members of the private bar, and that seeing that the court has ruled that persons have that facility available to them now and that they should be able to make use of it even pending on the outcome of the appeal at Privy Council, that the Public Defender's Department should pursue these matters.
Yes, thank you. Chair, through you. So maybe I should have clarification in terms of the matter that I was speaking of. So the matter I was speaking of that we're interested party is Joel King, which would have been the first bail application that was granted here, and that dealt with particular issues. So this is not the matter that has gone to the Privy Council. So we're not speaking about Akini Charles, we're speaking with respect to Joel King. Right. And so that is the matter that we're an interested party in. With respect to the other portion of the question in terms of being conflicted, absolutely not. We're an independent agency. We do what we have to do for our clients, so I do not see any conflict whatsoever. We represent our clients and we do it with their interest in mind and no other interests. So that is absolutely the case for us. With respect to private attorneys getting bail before the courts, absolutely. And it's not a question that we are not pursuing. Perhaps I need to be a little clearer in what I'm saying in relation to that. We have a number of persons who have actively given instructions with respect to bail, but we have been actively observing what has been happening in the courts and what are the criteria that the judges and, well, previously when the masters were doing it, what they are looking for. So because there are certain things that we think are important in terms of what will be a successful grant for bail, what we believe is, perhaps to use Member Hussein's terminology, we prefer to front load with all of our information, ensure that we have everything that's necessary, and that is what we're doing. So when I say we do not have active matters before the court, meaning there is none that is waiting a decision, but it's not that we're not actively in the process of doing the bail.
Okay. All right. Well, let me move on then to my questions about duty counsel. The duty counsel scheme, I think Senior raised it in one of his previous contributions. I've actually been part of duty counsel, and from my recollection, it is confined at this point in time to cases involving minors at the children's courts and capital offences. Is there any plan, one, to expand the duty counsel scheme? My second question would have been, would the COVID pandemic had an impact on your ability to provide that duty counsel scheme service to persons? Because, of course, going physically to the police station and all of that might have been a challenge for many attorneys. And I wanted to find out how many attorneys do you presently have on the roster to provide the duty counsel service? And fourthly, whether there's any plan to, again, because you're talked about expanding the number of attorneys in-house and on your actual internal structure, whether you would consider bringing the internal the duty counsel scheme in-house as well, rather than relying on the availability of external attorneys, because duty counsel is something that you get a call and you have to call around and basically look for an attorney to be able to send out into the relevant areas to deal with the matters. So would you consider bringing that in-house as well?
I will let the Assistant Secretary, Patrice Mendoza-Mason, tackle the duty council, but I could tackle some of it. If I may at least contextualize what duty council is about for people listening on. The duty council operates, it's a 24-hour line that the Trinidad and Tobago Police Service is required to call by law once a minor is detained for any offense whatsoever, whatever it is, and any adult citizen that is detained for a capital offense, meaning murder. So that's the current ambit of the law with regard to the duty council. And whether it's going to be expanded or not is, I know currently we are finalizing amendments to the Legal Aid and Advice Act because we are doing a complete overview, because you've had so much legislation that has come on board that affects, that interfaces with us and our duties. There are certain amendments that are being finalized to take into consideration all of that, and the issue, I guess, of the duty council and whether it should be expanded would be one of those things that would be is being looked at. But certainly that's how duty council operates. There are no current plans to have a duty council, in-house duty council team. At least there are no plans for that as yet. Because duty council, because your police station districts are spread out across the jurisdiction, they don't necessarily coincide with where our team would be. So it seems more prudent and more practical that if somebody gets if a police station from Rio Claro, for example, calls you to the council line, that you look for attorneys within the Rio Claro district that are on our duty council panel to get to that police station in a timely manner. So how the duty council is set up, it lends itself practically for the private bar who are members of that panel to actually treat with the matter, because those calls can come in at any hour of the night, day or night. And people closest to the police districts are the ones who you're going to tackle in terms of trying to get representation to the accused. With regard to the amount of people in the duty council panel, maybe I could hand over to Patrice Mendoza-Mason, the Assistant Secretary at this point.
351.
351.
Sorry, I didn't realize I said that alone. Yes, 351.
Oh, 351, okay.
351 of the submission.
Right, so it's 351 attorneys on our duty council panel at this point.
Question. As far as the duty council are concerned, there is a fixed fee to be paid for duty council. Is that not so?
It's a range of no less than $1,000 to a maximum of $2,500.
Is there any way where you can actually ascertain apart from what the duty council reports to you, what duty council has done in a particular matter? I say that against the background of being told that some duty council do not, trouble themselves to go to the police station and interview, which is supposed to happen, but they show up in court. So that all of the safeguards that should be there, how, the question is to be done in the presence of this one, all of those things, all of those rules are not being followed at times. But duty council is there nonchalantly showing up in court as though, duty council has done the best. So is there any way where you could liaise with the police station to find out? Of course, they could be colluding with duty council. What in fact should have happened has happened.
Well, Madam Chair, I think that would be, I want to believe those would be rare occurrences, because in terms of the forms that duty councils are required to submit to us, they also have to be signed by, in the case of a minor, a guardian or parent, in terms that the advice was given at the respective police station, etc. And so there is a track there in part of the documentation that is being sent, and that documentation is also part of the record of the TTPS. Every month, records are sent back to the TTPS with regard to all of the duty council certificates as part of the requirement under the Act. So there is that sort of verification process. Now, can what you're suggesting happen? There are always possibilities that people will try to fiddle with the system. But the TTPS, when incidents like that have occurred, have been proactive to indicate to us if there is a complaint that somebody did not fulfill their duty or whatever kink happened in the system. Because it's a collaborative stakeholder approach with regard to the issue of the detained minor or the detained adult for murder, there is a certain amount of collaboration that will take place between us and the Trinidad and Tobago Police Service. So I know there have been 1 or 2 incidents where they would have indicated that X or Y would have done or not done what they were supposed to have done, and we have followed up and dealt with that issue. But that is a rarity. I think a lot of our duty council panel is pretty aggressive in terms of how they deal with their duties. And the forms, there's so many forms and reports that they have to submit to us, including the client, as I say, signing off with regard to that, because sometimes a duty counsel appears at the police station and the client doesn't want duty counsel. And so sometimes they don't even want to sign the form. So sometimes, a police officer may say, well, okay, I'll sign it, indicating they didn't want any duty counsel. And sometimes, of course, you have duty counsel and private attorney appearing at the police station at the same time. In a case like that, of course, the duty counsel gives way to the private attorney that the family or friends may have retained for the detained person.
Are you satisfied that the facilities at the particular station, because it's not every station, as you know, that it is adequate for the number of children that may come before in the police station? As I understand it, sometimes it's just about 2 cells and you have more children, than expected coming there. And are you satisfied also that there is enough training of police officers on the role of duty counsel? Or sometimes they don't understand, they're not supposed to do certain things, or is it that the police don't want to understand? Are you satisfied that your outreach, that some duty, police officers they never heard about the rules of the children court and the rules of so many things. So I want to know if your outreach is reaching those officers.
I think we would have had those problems in the initial stages of the duty council where, police officers were unaware, even though we would have actually printed at our cost posters with regard to duty councils. And not only that, we do it in English and Spanish. And those posters would have gone out to police stations across the country. We would have had certain liaising with senior members of the TTPS with regard to when the duty council was being rolled out. It's hard, I would find it very much an anomaly for a police officer to say that they don't know that duty council exists in 2022, because it has become such an ingrained part of the system. I mean, in my visiting a couple of police stations, I have always made it my duty to look around to see what kind of information is being exposed to members of the public with regard to the duty council, and it is there at these stations I've gone to. And internally in the TTPS, I do see signs up with regard to if the child is detained, etc., etc., etc. So I think while that may have happened initially, that doesn't see. It's very rare that would occur now. In addition to which, we also do follow-up because members of the public, many members of the public, when a child is detained, are aware of the duty council. Sometimes they may not know whether the police would have called us or not, and they would call us directly, and we would do a double verification to make sure that we were called. For example, in a recent incident with the student who was detained in the stabbing of the other student, and was detained. I know I personally double-checked to make sure that the TTPS had called us because it was a minor being detained. And they had, in fact, called when I verified, and a duty council was already dispatched. So you have those kind of spot checks in terms of that the system is working, and certainly I think it is working at a pretty robust level.
My question really dealt with not really whether they know of duty council, but whether they know that they must not do certain things in the absence of duty council. You see, that is what happened. Anecdotal evidence is pointing out sometimes they're questioning the child and doing certain things, and there is nobody there.
Yeah, well, the TTPS is supposed to know that they have to call us before they actually question a child. And children that we have dealt with in terms of the duty council reports would reflect if anything had happened. And because generally they will ask the child, have you been questioned by the police before? Have they attempted to question you, etc., etc.? So that would be in any report if that anomaly would have occurred.
Member Scotland?
Chairman, Mr. Raghubar Singh hit on a note I was going to ask. At page 45 of the public defender's submission, and also I will suspect running around in the consciousness of Legal Aid and Advisory Committee, is the whole aspect of amendments to the Legal Aid and Advisory Act in order to meet the current pilot project and fluid situation. Could you briefly tell us what are these amendments that are proposed?
Well, the amendments, they would have, I don't know if Hassim wants to take, at least from the criminal side, what some of the public defenders departments recommendations were to those amendments, and Patrice Mendoza Mason can answer to the other amendments that would have been done, because there's an amendment committee that would have been collating all the various amendments that we are doing to the LAAA Act. So if I can hand over to Hassim, at least from the criminal perspective, what their amendments would be, recommended amendments are. Member Scotland, you're on mute.
Briefly, so that the public can just get a sense of it. All right?
Yes, absolutely. Chair, through you. With respect, I can't remember exactly every single amendment that we proposed, but the major amendment that we were proposing has to do, for the criminal side, has to do with pretrial work. In light of the criminal procedure rules, and the sheer amount of work that is expected to do prior to trial, that has posed quite a significant problem, because the way that the Act is worded currently and the way that payments are made currently is that it's upon commencement of trial. So generally, when you're paid your X amount of dollars at the end of the trial, it means really it's for work that you would have done during the trial. And also we have to, in light of the change whereby the judicial officer who is authorizing the fees is not the same as the person who's conducting the case management conference and who is actually doing all of the applications and ordering all of the necessary things that have to be done upfront, that being two separate things, we thought that it was necessary to put that into place, or to suggest that, because realistically, one of the reasons that persons at the external bar didn't want to do legal aid is because they felt they were not compensated for just the sheer amount of work that they were doing. And when the criminal procedure rules came into effect and effectively made the workload up front, whereby you're doing all of your applications up front, you're doing all of your grounds of objections, evidential objections, everything that you would normally perhaps waited till later on for, where the judge would have had sight of it and know that you would have done all of these things and consider that in the fee that is being authorized at the end. It meant that now a lot of it was being done up front. So that is the primary recommendation that we made in terms of on the criminal side. I don't know if Mr. Morgan remembers any of the others, and I'll allow him a chance to assist here.
Good morning, Chair. Again, through you, allow me to answer Member Scotland's question in part. We have also considered the introduction of sufficiency hearings, and to address the payment to attorneys for work done during those matters, because it isn't currently addressed under the Act. So we have also made recommendations for amendments to cover those proceedings, and a particular fee structure to acknowledge the work done before the master and at various stages.
Madam, and from the legal aid?
The civil side.
Mr. Scotland?
I was waiting for an answer from the civil side, but maybe none is forthcoming. I can move on to my next.
No, Patrice, Patrice Mendoza-Mason can tackle the amendments from the civil side. Patrice, are you on?
Yes, thank you, Mr. Raghubar Singh, and thank you for that question, Mr. Scotland. Madam Chair, with your leave, with regards to the civil side of the authority, one of the major amendments we were looking at, and this was based on some challenges that the authority would have faced historically, would have been during the period when we don't actively have a board and the director, chairman per se. So one of the major amendments we were looking at is diverting some of the authority that the director would have to the secretary, so that some of our day-to-day functions can in fact continue effectively during the period that we may not have a board, or the board's period would have expired and we are waiting on the reappointment of the members, and particularly the director. So that is one of the major amendments we were looking at. We also would have had, and this touches on the criminal side of it, an interpretation summons, and certain recommendations came out of that matter from the court with regards to how we deal with multi-accused matters. And we were also looking at that particular area in terms of some of the recommendations made and how we can implement that as part of our statutory requirements. Like I indicated, most of the amendments had to do with legal aid procedures, more so in terms of administrative functions.
Madam Chair, through you, I have two more areas I'd want to interrogate. I want to ask the chairman of the legal aid and maybe the public defenders department, have, since the advent of the COVID-19 pandemic and the virtual setting, has the authority and the public defenders department put any mechanisms in place that would deal with the ability of the authority and the public defenders department, let's say, to communicate with accused who may not be able to see them in person? Has any virtual mechanisms been put in place to deal with that?
Madam Chair, well,
Senior is muted.
I anticipate that there are two sides to Member Scotland's question. One would be persons in custody and the inability of attorneys from the Public Defenders Department to visit the prisons. Yes, that system has been set up. It has been working. We have received laptops from a High Commission in particular that we have deposited at the prisons, and there's software set up and connectivity links so that attorneys can communicate with clients who are in custody and cannot be visited by the attorneys because of the obvious health.
And the prisoners are aware of this, that they can access this with the attorneys?
Yes, they do access and hold conferences via the laptop system that we have deposited at the prisons with the commissioner. And that system is set up, and I understand it has been working. I don't know if there are any particular challenges that Ms. Sheikh may want to highlight, but I understand it has been working smoothly.
If I may, Madam Chair, through you, just to add to what Senior has said, yes, we have had the system set up. We were the only persons who had a virtual system set up. The Law Association only recently started in the past month to have their system up and going. We have nearly, I think, basically, we tried to cover all of the prisons. We have 2 at MSP, 2 at Golden Grove, we have at Women's Prison, we have at Port of Spain, we had at ECRC. So we have a mechanism whereby each prison is adequately serviced. What we do is that if we have accused persons at any of those prisons that we are required to see, meaning that they are our clients, we do see them. We set up an appointment, we send a list, we have an arrangement with the prison, we have persons who we send the list to so that they know that we need to see them at a particular time, and that is facilitated. As I speak, we actually have what we call Form 9 visits taking place, which is the actual processing of persons who wish to have legal aid. So they have a process in the prison whereby they make a request of the welfare officer and indicate that they wish to have legal aid. And that is the current process, even prior to COVID, where they would put their name on a list and indicate that they want to have legal aid. And usually the legal aid attorney would go into the prison and process them and fill out the documents and so forth. That has been adapted due to COVID because we were not able to go in. And that has been adapted where we do it over the computer system. We send the form, we digitally sign it. It is commissioned, everything is done over the computer. So we're able to process it effectively and then send it off to the relevant court that it needs to go to be authorized. So in terms of our setup in the prison to deal with the accused persons who require it, we have more than adequately been able to capture it. It is actually very efficient because we're able to move a whole lot faster and get it done quickly because you can have multiple laptops at the same time.
Is this system available in Tobago?
With respect to the Tobago?
The virtual where there can be a virtual conference between the attorneys and an accused in Tobago.
Yes, there is a system. There is also a computer that has been set up in Tobago.
Madam Chair, through you, and I really feel maybe Mr. Peterson, Senior Counsel, Mr. Raghubar Singh can answer this question. There was a synergy between the Legal Aid and Advisory Authority and young attorneys wishing to practice at the criminal bar, whereby they would get a start. And we can't bury our heads in the sand and say that this didn't exist. So they would go at a cause list, they will get appointed to they will get their, of course, do their homework, get their experience. They will go to the magistrate's court. The magistrate will see persons who are there unrepresented and who may not have the means. With the coming, and that system spawned lots of attorneys and made them more experienced. With the coming of the Public Defender's Department in the league under the Legal Aid and Advisory Authority, Senior Counsel, do you see that symbiotic development being eroded and becoming a thing of the past?
I don't see it as becoming a thing of the past, but I think Mrs. Sheikh had indicated earlier part of the problem that may have been affecting what you're talking about. Because remember, the criminal bar shrunk over years and became very, very small. And that is what I think created the need and the urgency for the establishment of the Public Defender's Department. I understand what you're saying, that previously a lot of attorneys used to cut their teeth in legal aid. They go to court, the court appoint them from the dock, and they get a dock brief and they continue. Some of that continues in the magistrate's court. When I go there, I haven't been there in a while, but when I go there...
You have not seen it.
I heard magistrates saying, are you on the panel? And then they would assign persons. Some of that still takes place because even when we assign matters, heavier matters to more experienced attorneys, we tend to assign young attorneys as instructing attorneys. So they will see the more senior attorneys at work, and some of that transfer of knowledge will pass on to them. But the Public Defender's Department had to be established, in my respectful view, because the system was grinding to a halt due to the shortage of lawyers being attracted to the criminal practice at the criminal bar. And that, so there will still be some of that synergy and training, as you refer to, Member Scotland, but then there's also persons who enter the Public Defender's Department at the Public Defender's level, entry level, young lawyers, they will also get that same learning in-house. And then we also assign younger members who are at the bar, who are not in the Public Defender's Department, 2 more experienced attorneys to get that transfer of knowledge.
Before I go to Ms.
Sorry, Madam Chair, I always defer to you, always.
You have a burning question?
Madam Chair, I will defer to you. If we have the time, I will come back to it. I've looked at the time. I don't want to hog the...
You are so kind, Mr. Scotland. You are so kind.
Thank you, Madam Chair.
I'm grateful. I'm grateful. Now, in your submission of the Legal Aid Advisory Authority about pandemic condition, you stated there were the options of obtaining advice over the telephone, through the webmail, or in urgent cases by visiting any district office in person. Were video conferencing platforms such as Zoom or MS Teams used by the authority to engage members of the public during the COVID-19 pandemic? If not, why not? And I just want to add on, at a public hearing held on Wednesday, June 22, 2022, the JSC Social Services and Public Administration learned that victims of domestic violence were unable to access the services of the Legal Aid and Advisory Authority during the COVID-19 lockdown, whereby calls and emails went unanswered and persons were turned away from the building. Also, I understand from attorneys that during the time between 8 o'clock and 12 o'clock, you were able to access telephone, by telephone, the Legal Aid Advisory Authority. After 12, everything went to voicemail. They said they would call you back. Messages were left and attorneys were not called. So what exactly happened? Could somebody explain?
I mean, Madam Chair, I would have addressed that issue at that JSC meeting, because I would have sent a response to the chair of that meeting with regard to that particular issue. And if there was a gap in our system, we checked in terms of the person who would have raised the issue of non-communication via email, etc. And our team that looked into it, because we have a very aggressive team that follows up on email correspondence, and there was email interaction with that respective client. And so we were a little confused as to why that would have materialized in the way it did at that JSC. In fact, it ended with us saying, please send your contact information so that we can further progress the matter with regard to the issue. And they were not responded. We were not responded to. So there was an exchange of email, and there was an exchange and interaction with regard to that particular issue. With regard to not being accessible after 12 noon, it's strange for attorneys to say that, because what we have done, even if people are on roster, especially during the pandemic, when people worked from home, what our IT department would have done is that all of the major interfacing that would have to take place with members of the public, those extensions were routed to cell phones, so that if the extension was ringing but they were working at home at that point, the call would still come through to their cell phone. Can there be systemic gaps? I guess there can, but certainly any attorneys who are part of a big group of our stakeholders should know how to get in contact with any of us basically at the authority, because a lot of them are colleagues. So that's an interesting complaint. But certainly, if there were gaps in the system, certainly we would want to address them. But I know that we were cognizant of the fact that sometimes people were working at home and extensions may be unanswered. And so we simply had technicians come in to route many extensions to respective cell phones, so that issue would not have arisen during the pandemic when people would have needed to access our services. And certainly during the pandemic, our figures indicate over 9,000 people would have visited and would have gained advisory services and legal aid access during that period, which is pretty much in line with our annual figure. So 9,000 plus people would have accessed us during the pandemic, which is a similar figure outside of the pandemic period. And because we have made such a lot of investment in our digitization process prior to the pandemic, we were moving as briskly as we could to becoming a paperless institution. Our webmail interface grew by leaps and bounds in terms of people accessing us through that platform. But you registered that there was a complaint. I know that JSC complaint, I did address it, and we are sending a written report to that JSC with regard to what we discovered. And well, with regard to the issue of some people saying that they won't be able to access us after 12, it's something that I will just have to address and look at in terms of our records and see where that gap could have existed.
If ever there was a robust defense, you have provided it. Thank you very much. And your chairman, director, is very present and he has heard you. Mr. Hossain, you have been very patient, as you always have been with me. The floor is yours.
Thank you very much, Madam Chair. I think it's an agreed fact based on the submissions of Mr. Scotland and the chairman of the authority that younger attorneys tend to cut their teeth into the legal profession with experience from the legal aid department. However, these younger attorneys may not have the lucrative briefs or have the opportunities in order to earn as much as more of the senior attorneys, and therefore they may depend on the fees that they earn from the legal aid authority. And one of the complaints that we have heard is that there has been delays in terms of the payments of fees, especially on duty counsel, and those matters that were completed by some of the attorneys on behalf of the legal aid authority. Can you indicate or give us an explanation of why there's this lengthy delay in terms of the payment, and if that issue has in fact been addressed?
And perhaps, in answering that, you can give an idea of how many lawyers have withdrawn from the Legal Aid and Advisory Authority panel because of their frustration over payment of fees.
Payment of fees.
He smiled.
Madam Chair, I'm not so sure if we have Patrice. Maybe you could look to see how many would have withdrawn. I know that at points those issues of payment crops up from the external bar. I think currently we are pretty much on time and pretty much dealing with our payments in a timely manner. Sometimes it can be a resource issue, but currently, I believe we are up to par, because if attorneys are not getting their payments, they certainly make it known to us. Now, with regard to payments that emanate from the High Court and the magistracy, because that's where judges decide how much an attorney gets paid, and they provide us with an authorization to pay fees which is our document to pay an attorney. Sometimes there is a delay from the court's perspective in sending us these payments. And that is the keepback. So the keepback is not at the authority, it's at the court or judicial system. We send constant reminders, whether it be to the magistracy or to the High Court, with regard to outstanding payments when attorneys raise the issue with us. And sometimes even if they don't raise it proactively, once we know a matter has been completed, we send for the request for payment. It's an automatic document that we send to the judiciary or the magistracy saying, this matter was completed on XYZ date. Could you forward the authority to pay fees? You have certain administrative kinks that happen on the magistracy or the judiciary side. For example, it may have been a court appointment. When a judge or magistrate appoints somebody from the bench, we have no notification of that. And sometimes the only notification we have is an authorization to pay fees that comes to us, and we are like, well, we have no file for this client. And we realize that this client emanated from the bench. So we then have to now say, well, we need some verification that this is a court appointment so that we can pay on it. And then it kicks in now an administrative route where we have to write to the court to say, well, is this a court appointment? Because we don't have a file on this client. Can you verify it's a court appointment? Because we can't pay unless you verify it. And sometimes the response can be a delay depending on the magistracy or the judiciary. So all of that can retard an attorney getting their payment in a timely manner that quite frankly has nothing to do with us specifically, but the system and the systematic delays in terms of making sure that the record is correct, because you are dealing with money for which for all intents and purposes are allocated to us by the state and we are responsible for. So we can't just pay unless all of those verification procedures are met. But certainly, I mean, with duty counsel payments, I think by and large, we deal with them as quickly as possible. And I know personally that a lot of those payments go out in a timely manner now. And so I think a lot of our backlog that we would have had with regard to payments has been addressed. And I think we are in a good place at this point.
Has there been a change recently in, the mechanism, the procedure with fees? I mean, what the requirements between the court and so on? Was there?
Well, the entire process has now gone digital because the judiciary, of course, has gone digital, and we ran into the problems of because invoices we have to follow the accounting protocols. And we had to actually had a meeting with judiciary and the court executive administrator on this issue. We had a virtual meeting with the judiciary on the issue of payments and indicating that, look, we actually needed the hard copy. That was because that was our approach in the past, and the judiciary was adamant, of course, in that meeting that digitally signed documents are legal, and therefore their documents being digitally signed was legal, and we could process it. We have now gone into a system where we have accepted those payments, so the entire process is now digital. And we do our own verification and stamping and verification before it's issued to payment. So the entire system has changed from being a hard copy system to being now a digital system.
So the bottom line is that we expect attorneys to be paid much more timely now because of this new digital move on the side of the judiciary and side of the legal aid accepting.
Yeah, once we get the payments, and as I said, once there is no administrative kink, because sometimes, for example, a member was signed, sometimes an attorney may, for example, pass over the brief to another attorney. And the payment comes in, but the court recognizes who they have registered as the assigned legal aid attorney. And sometimes that attorney may have told the judge, well, this person appearing, and they may put the payment in that other attorney, and we can't pay because our records are like, well, how did this attorney get into the matter? And so I'm just giving that as an example of administrative kinks that come into the system because we are dealing with money allocated to us and we are responsible for it. We have to make sure that we can verify all of these systems so that when we are audited, we don't have any flags with regard to how payments were issued. But certainly it speeds up the system because of the electronic exchange.
Madam Chair,
Page 8.
Sorry.
Page 8 of your report, achievements, it is evidence of meeting its mandate. For the period October 2020 to May 2022, despite the onslaught of the COVID-19 pandemic and its effect globally, regionally, and most importantly, economically, the authority was still able to function effectively. And you spoke about most of the public and private sector operating remotely. The authority having put these mechanisms in prior to COVID-19 was still able to achieve its mission and vision effortlessly. Now, in light of all of that, I am wondering how you were able to function effectively when there was no board between July 2021 to February 2022 to actually approve appointments and so on during in the civil matters. How did that happen? And I would also like to find out from the Attorney General's department, why did it take so long to appoint a director?
Madam Chairman, with regard to the representation of people during that period when we had that gap, we had to find innovative workarounds to make sure that people were represented. Many times we opted for internal attorneys dealing with matters as much as possible with regard to making sure that people got representation. So a lot of that would have been done. And in addition, from time to time, if it was an urgent, complex matter, we would have issued emergency certificates, which allows under the Act that aid can be granted to subsequent approval by the board. And when the board eventually came on board, all of those emergency certificates would have been regularized in those exceptional circumstances where we really had to use it. So that's a lot of how we navigated at that point. The Public Defender's Department, of course, would have navigated because a lot of the appointments and orders will come from the court directly to us. And a lot of the times they would have dealt with a lot of the internal appointments through the PDD. With regard to why the delay, well, I could pass that over to the Ministry of the Attorney General and Legal Affairs.
So, but that's the entity that I asked the question.
Morning, Chair. Just to clarify, there was a delay with regards to the reappointment because of some going back and forth between the appointment of the different members of the board. In particular, there was some going back and forth between NIB and the ministry and who would be the representative from NIB to be on the particular board. So that is basically what would have caused the delay. But it was rectified as quickly as we could have, and the ministry would have continued providing support to legal aid, even in the absence of the board, to ensure that the functions continued uninterrupted.
7 months is quickly.
Madam Chair, if I could come in there, that is always a lot of statutes that are structured in similarly to the Legal Aid Act is what creates some of the problems in the delay from the end of one board to the life of a new one, because it's not just a matter of numbers of persons, but of persons with particular disciplines and persons from particular institution. So, for example, if a member to come from the NIB board and the NIB board might have expired, the Legal Aid board might expire shortly after, and we'll have to await the appointment of the NIB board and the nomination from NIB to satisfy the statutory requirements of the Legal Aid board. And that is part of the problem.
Yeah.
Thank you.
Madam Chair, if I could just be allowed an indulgence, I noticed that your question also was not answered, that part of your question as to how we were able to deliver the service in the absence of the pandemic and the absence of the board. We dealt with the absence of the board, but I think we were able to deliver the service because of the resources that were made available to us by the PS, so that we had the digital platforms up and we had the laptops. I failed to identify and recognize earlier that the laptops I spoke about in answer to Member Scotland, some of them came from the British High Commission, which we are grateful for, and we want to recognize and underscore that. And we got some from the good services of the PS from the Ministry of the Attorney General, so we were able to keep the service up and running. So I don't think that those contributions should go unrecognized.
The Attorney General submission, you stated that your department has been requested to authorize on behalf of the Public Defender's Department the necessary implementation documents in order to advance the development and implementation of a case statistics monitoring system for that department. What is the project timeline for this case statistics monitoring system for the Public Defender's Department?
Well, there's already a case management system, but it's really one that we want to now improve upon. So we are still in the review stage at this present time while we're looking at it, and we're hoping that because we are digitizing and we are looking at making sure that all the case management systems that we do have in Office of the Attorney General and Legal Aid by extension are, the most optimum and really provide the kind of support that the department requires. So we're really currently just reviewing the existing system that they have, but we are moving very fast with regards to digitizing the entire ministry, and that includes legal aid. So, like I said, I don't think it's going to go past possibly a year, and hopefully we'll be able to implement by next fiscal.
You also said that due to COVID-19 restrictions, the outreach team of the Legal Aid and Advisory Authority had no scheduled outreach events of its own. So why not use other ways of reaching people? You know, you have how many television stations now? You know, there's so many ways of reaching people. And so what do you plan to be executed in the near future? What platforms are you going to use to disseminate information regarding the Legal Aid and Advisory Authority?
Well, I do know that the Legal Aid and Advisory Authority has recently almost completed the revision of their online system, and part of it is outreach that would be available on their website with regard to giving information pertaining to the institution and how persons can best access their services and provide feedback. And as I said, we are really trying to promote the digital transformation of all our services. So that is one of the main areas that we are focusing on, which is the more of an online outreach.
Madam Chair, if I could just weigh in on that issue. During that period, the LAAA would have partnered with the Ministry of Social Development in terms of doing some pre-recorded outreach that would have been done. And generally, I mean, pre-COVID, we would have built relationships with several stakeholders who use us annually in terms of outreach, in terms of their various disciplines or their various spheres of influence. So we get many, prior to COVID, we have gotten many requests from various stakeholders, from schools to companies, etc., to come to talk to their staff and stuff about legal aid, about legal issues and stuff like that. And we have always consistently facilitated any of those outreaches. But with regard to the online and during COVID, we partnered with the Ministry of Social Development and had a series of sensitization and was pre-recorded. 2 senior legal officers attended and was various topics. NGOs also attended as well.
Remember, I spoke earlier before I go up to Mr. Hossain about the Law Centers Federation and my experience with them and the mandate. They said, you know, that if you're into legal aid, then you must also be into legal education, and the lecture series I had started. And I am always amazed as to the extent of legal illiteracy in Trinidad and Tobago. People just don't know so many things. I remember way back when the Domestic Violence Act first came out in 91 or so. And I was at a forum at UWI, organized by Diana Mahabi and Wyatt, and the people were castigating the Legal Aid and Advisory Authority for not granting aid to domestic violence victims. And I mean, I said it's a good thing I'm here. So I had to explain to them, legal aid is a creature of statute. You cannot, at that point, we could not have extended legal aid to victims of domestic violence because the law just did not allow it. So I told them I'll come to the law school, and we were doing it, you know, until the law changed. So there's so much that this week, I think it was, or late last week, somebody wrote about there should be a law that parents should be held accountable for crimes committed by their children. So much in the Children Act that people are just not aware of. So, I mean, I will offer my service to you to point out areas where you could actually have programs to educate members of the public on laws that impact upon their general life and that they should know about, and they're just not aware of what is there. There's a lot of work, Sometimes the Children Authority does some. I've had a quarrel with them too, that sometimes they're not following what they're supposed to do in terms of, because even their education is lacking. So there's so much about all the conventions that we've signed. We just don't know. They don't even know the conventions. And the concluding observations of the Committee on the Rights of the Child, what they said about Trinidad and Tobago is that we should be educating the parliamentarians. They sit down in Parliament, I know they don't know. And all of these people, the teachers, I held a forum, and I'm asking school principals up at the law school one day, tell me some of the rights of the child. They stop at 3, and that was it. That was it. So people don't know a lot. So there's a role for the authority in conjunction with other agencies to do that public education. I think is extremely important. So take it on board for me, please, and see what you can do. I'm willing to make suggestions about things because, my time is at a premium these days. So what can where the needs are. But if you look in the newspaper, you will see how many things people don't know. As I told you, that letter came out, I think, if not late last week, this week, that parents should be held accountable. So there's a lot that is happening, a lot of information that needs to get out to the public. So please, I see you have that you outreach, and get busy with that for me, please. Mr. Hussain.
Thank you very much, Chair. With respect to the outreach, and I think that's a very good point that Mr. Raghubasing made. As an MP who is also an attorney at law, on office day you will find yourself having legal aid clinics because most of your constituents who come to see you comes with legal issues. Obviously, you can't take every single matter. You can't represent every single constituent. And I think maybe if the Legal Aid Authority can in fact have some level of partnership with the MPs' offices, all 41 MPs, because we have persons here who I believe deserve the representation. I believe I would have sent through my office several persons across the authority, and I think they would have gotten assistance. But I think maybe this JSC gives us the opportunity to start that level of partnership with the MPs' offices in terms of getting the Legal Aid Authority out there advertising your services, because it's a symbiotic relationship between your authority, your statutory mandate, and what the representation of those who really need the Legal Aid Authority. So I think that is something you all could probably take into consideration, whether or not I can facilitate the legal aid at any time in Baratoria San Juan. You are on the outskirts of my constituency. So it's something that we could probably look at in terms of a partnership. But there's just one more question I have. And this is a question that persons will come to me and they will say that they don't want to go to the legal aid. And this is not my view, because I know there are very bright, hardworking attorneys who came and who are still at the Legal Aid Authority. Some of them are my colleagues. But some persons rather borrow money or get the money somewhere to hire a private attorney rather than going to the Legal Aid Authority where they are competent counsel, because they feel as though they would not get the same representation as that of a private attorney at law. And that is something that we can't bury our heads in the sand and pretend it doesn't happen. What has the authority done in order to boost public confidence within the Legal Aid Authority in terms of having the clients and persons who need legal representation come to you all in order to get that service?
Well, a client, Member Hussain, through Chair, a client who requires legal aid, needs to elect to come to legal aid. I think this has been an age-old problem. I don't think it's a new thing, where people may have the preconceptions of what level of service are they going to get from the authority. I think many clients have after they have come into our system, many have been in praise of us. And many have, I know of times when people would write and say thank you and say it was the darkest moment in their lives, and the authority was the one light that brought them through it. And you get those kinds of thank yous that come from clients that we have assisted throughout the years, and thousands of clients, thousands we have assisted throughout the years, and successfully I'm talking about. So in terms of boosting confidence, I think that's a work in progress. I think a lot of it, in a society like Trinidad and Tobago, a lot of it is word of mouth. I think, for example, the PDD is doing an excellent job in boosting that aspect of it, because you have even judges remarking on the quality of service that the PDD provides in court. So I think all of that accumulates. It's a picture that is painted from different angles. Our stakeholder approach and how we interface with stakeholders, how we do the same outreaches, and we do outreaches in all various manner, companies, different, sometimes with NGOs, and our presence there and what we talk about always wins new clients. So it's a constant work in progress in building and establishing that picture, but I don't want it to be disregarded that a lot of clients hold us in high esteem. So for that one client that would have said, okay, for those clients that will say, well, I don't know what kind of representation I would get, there are many who would validate that they got the kind of experience that maybe they did not expect.
Madam Chair, if I could weigh in on that point. The observation of Member Hussein is one that I have heard in many years being at the bar. It's just a preconceived notion that persons believe that if they're getting something that they're not paying for, it's not good. That you have to pay for it to be good. But what a lot of clients realize when they come to the legal aid is that some of the attorneys they will get from the panel and some of the attorneys now that they will get from PDP, experienced attorneys, that they would have the same attorneys they would have been paying good money for on the outside. So it's really a work in progress, I agree. But it's really also for the professionalism of each attorney who is assigned a matter. Because whenever I had an opportunity to speak to young lawyers just entering the bar, I always say to them, cut your teeth in legal aid matters, but let no client be able to tell whether you are being appointed or retained by legal aid or whether you have received one of the most lucrative briefs in your career. You must perform at that level. It should not matter how you have been retained. So it's really a preconceived notion, but when persons come to the pudding, they realize how good the eating is.
I was about to ask for brief closing comments from the chief officials present. And it seems to me that I've been preempted by Mr. Peterson's remarks, because that is such a lovely note to end on. So thank you, Mr. Peterson. I think you will agree with me. I do not need to call on you anymore for closing remarks. Thank you. You have done well. So I would turn to the other part of legal aid, which is the Public Defender's Office, for closing remarks, and then the Attorney General's Department.
Thank you very much, Madam Chair. I would just like to thank the opportunity to this committee for giving us the ability to indicate what we have been doing. We believe that we have been working hard to add to what Senior has said and Mr. Raghubar Singh has said. We are actively working to improve public confidence in what we are providing. We believe that we have put the time into the training and we are actively working in the courts to ease the criminal backlog as best as we can. We're here to work and we are happy to do so, and we continue to do it every day. Thank you.
Last but not least, the Attorney General's Department.
Thank you, Chair. I would just like to reiterate that, the Office of the Attorney General is completely committed to prioritizing legal aid and the advisory authority, as well as the Public Defender's Department, because, we have been actively working with them on a regular basis. And in addition to which, the permanent secretary is also part of the board. And so therefore, all of the information that we would normally provide or that we would normally have to come to the ministry, we try to make sure that it is done as quickly as possible. And we are in full support of all the efforts that are being made by the Legal Aid and Advisory Authority as well as the Public Defender's Department. Thank you very much.
That must be very comforting to the Legal Aid and Advisory Authority. I'm sure they've taken note of it. So there will be no complaints. They'll be fully resourced because they have full support of the Attorney General Department. So it remains for me now to thank all of you, to thank the members who have stayed the course until the end. We are very conscious that some of you have to Parliament this afternoon, and we want to make sure that you are fortified, so we'll allow you to get your lunch, your hour's lunch. So we're making sure that we give you that time. I want to thank the procedural staff for their, the Office of the Parliament for the assistance that they give. It is amazing, but we are in communication. We do all hours of the day and night. Believe you me, we do not recognize sleeping hours. I would send a WhatsApp or an email and get a response. Sometimes I feel so guilty, but not too guilty to do it. And I am very, very grateful. They're always there responding. Even on a weekend, nobody says, Senator Thompson, I am on a break now. So, I will really try the next term. This is our last meeting. Not to push them too hard, but they have been really magnificent, and I'm always very grateful to them. I would like to thank the viewing and listening audience for staying the course with us. And we always listen out for whatever comments you make, whatever you send to us. We try our best to accommodate you. We always listen. And I thank you for being there with us. And we know that some of you go back and you listen to the tape again to see where we did well or didn't do so well. And you may send a comment or two. So we are grateful to you for all that you have done, that you are with us. And I must say, I thoroughly enjoyed seeing the old faces again from Legal Aid and Advisory Authority. Sometimes I think my heart is still with you, having been with you for all these years and then going to the other type of legal aid, the law school legal aid clinic. And I hope you are continuing that relationship with the law school's legal aid clinic. Yes, I tell people sometimes, so I'm very happy about that. Because although I was on the board before I joined law school, people think that I went, that law school is part of it, and we've continued that relationship. So sometimes I tell people, you have that option as well to go to the Hewarding Law School Legal Aid Clinic, and I expect that they will be back on stream. COVID is going behind us, although some people want to jam and bring COVID back. I would ask you, please, to remain to be safe. And I find Mr. Peterson laughing a little too much.
I saw it on social media, Madam Chair. I saw it on social media.
Saw it on social media. All right. And I hope that if you are in the vicinity of all of these goings on, you'll remember that our Minister of Health, try to help him to help us. Yes? And when you go to to these parties, remember also that if people are leaving your house to go to these parties, those of you who are parents, please try to encourage them to dress as though they're not going to the beach. All right? So that we want everybody to be safe. We want everybody to live a good, long life and free of legal problems, either civil, matrimonial, or whatever. But legal aid is there for you, whatever the type of problem that you have. I thank you with all my heart, you Legal Aid and Advisory Authority, for all that you do for our country.
Thank you, ma'am.
And this is the end of our session. Enjoy Parliament, those of you who are going to Parliament this afternoon, or have a good weekend, and see you next session. Bye.
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 Thank you, Chair. Goodbye.
Thank you.
Thank you, Chair. Good afternoon,
Thank you,
everyone.
Chair. Good day.
Afternoon, everyone.